A common question raised by parties dissatisfied with an arbitral award is, can I challenge this? Broadly, an arbitration award is final and binding. This is a key feature of arbitration, which aims to provide a conclusive resolution to disputes. However, there are limited grounds on which a party may challenge an award. These grounds, which rarely involve revisiting the tribunal's decision on the facts, are usually governed by the law of the arbitration seat. In England and Wales, the Arbitration Act 1996 sets out three broad grounds for challenge. First, under Section 67, relating to substantive jurisdiction. Second, Section 68, concerning serious irregularity. And third, Section 69, in relation to an appeal on a point of law. Taking each of those in turn, under Section 67, a party can apply to the court to challenge an award on the basis of the tribunal's substantive jurisdiction. This includes questions about the legitimacy of the arbitration agreement, the scope of it, and the proper constitution of the tribunal. Notably, the parties cannot contract out of Section 67. However, if a party participates in the arbitration despite being aware of a jurisdictional objection, they may lose the right to challenge under this section. Notably, parties cannot contract out of Section 67. However, if a party participates in the arbitration despite being aware of a jurisdictional objection, they may lose the right to challenge under this section. Turning to Section 68, that section allows a party to challenge an award based on serious procedural irregularities that affect the tribunal, the proceedings, or the award itself. The irregularities must cause substantial injustice and may include failures to comply with the tribunal's duties, improper procedure, or issues like ambiguity in the award. Like Section 67, parties cannot opt out of this provision, and they risk losing the right to challenge if they do not object to an irregularity when it arises during arbitration. Third, Section 69 permits an appeal to the court on a question of law arising from the award. Before appealing, parties must confirm their rights to do so, as they may have agreed to opt out of this process. If no opt-out exists, the court will only grant permission to appeal if it is satisfied that A, the legal question significantly affects the party's rights, B, that such was part of the determination, and C, meets one of the following criteria. 1, the decision is clearly wrong, or 2, the issue is of public importance and the decision is open to serious doubt. These criteria set a high bar for appeals, and without meeting them, permission will not be granted. In terms of procedural requirements and time limits, when the arbitration seat is a neutral country, the lawyers involved may not be qualified to file a challenge in the local court. For example, an English lawyer handling arbitration seated in, say, New York, may not be qualified to argue challenges before the US District Court under its procedural law. In such cases, the challenging party must engage local counsel with relevant experience. In England and Wales, challenges are made using Form N8 and must be filed within 28 days of the award's date or from the notification of it. Our arbitration lawyers, forming part of Edwin Coe's commercial disputes team, are experienced in advising and representing UK and international clients in the world's foremost dispute resolution centres, from the Americas and the Caribbean to Europe, Africa and the Middle East. In particular, they regularly act for clients in relation to challenges of arbitration awards and appear in the High Court.